Does call the case People versus Kent Robinson.
This is how a courtroom day really begins. Quiet, procedural, almost calm on the surface. But don't let that fool you. These first few seconds are the gateway to a chain of decisions that can change lives permanently. Today we're watching multiple defendants cycle through the same courtroom, but each case carries its own weight, risk, and consequences. And the first one up, Kent Robinson, immediately sets the tone. Bond issues, new charges, prior weapons cases. Those words should already be raising red flags. Bond hearings are not just about money, they're about trust. The court is deciding whether it believes a defendant will follow the rules if released. When someone already out on bond picks up new charges, especially something as serious as domestic violence, the trust starts cracking fast. Judges don't just look at what's alleged, they look at patterns, timing, and risk to the community. As this hearing unfolds, pay attention to how carefully the judge questions the defense. That's not hostility, it's scrutiny. Because once bond is denied or continued, the clock starts ticking differently for the defendant. Freedom versus a jail cell while waiting for trial, and the stakes could not be higher. Keep watching, because this case quickly turns from routine to revealing.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Robinson. Would you please state your name, sir?
Kent Robinson.
Your Honor, we are requesting an adjournment. I just received a police report today. It also would like to address bond.
Probable cause conference will be adjourned. Is this the only thing holding him?
He does have a $100 bond in one other matter that he indicates he would be able to post. So essentially it is.
February 12th, 2026, 9 a.m. As to bond briefly.
Your Honor, Mr. Robinson indicates that he is a lifelong resident of Ypsilanti. Here in the courtroom present is his girlfriend. Her name is Miss Jessica Horn, and she is currently expecting. He indicates that he has been employed for 6 years with a landscaping / snow removal company, and he can do that job. He also states that at the time of his arrest, he was picked up on at the time of his arrest, he had been, Your Honor, are you looking for why he does not have a bond right now? I can address that as well. Are you looking for why he is being held on this matter?
Yeah, I mean, you're asking me to change that, I would presume, because his bond is denied at this point for a violation.
That is correct. And we are prepared to address that. In terms of the violation was the new case that I just spoke of. For that matter, that was involving another young woman that he is no longer involved with. It's my understanding, resides in Ohio, so there's no risk of harm to her. If Your Honor were to put a no contact order, he would continue to reside here in Ypsilanti and would continue to reside with his sister. And he also has the opportunity for employment.
Well, I'm just trying to figure this out. So I have 3 weapons charges that he's before this court on. He's out on bond on that and picks up a domestic violence.
This is the moment where the courtroom temperature rises. Judge Simpson lays it out plainly. 3 weapons charges, already on bond, and now a fresh domestic violence allegation. That combination is devastating for any bond argument. From a legal standpoint, this isn't about whether Mr. Robinson is guilty of the new charge yet. This is about whether he followed the conditions of his release. And based on what we're hearing, the court believes he didn't. Defense counsel tries to pivot, emphasizing employment, family ties, a pregnant girlfriend, and the claim that the alleged victim lives out of state. These are classic mitigation arguments. But here's the problem. Bond is conditional freedom. When a judge hears new charges while already on bond, especially involving violence, that weighs far heavier than character references. And then comes the prosecution's response. Firearm possession as a felon, delayed police notification, fear at a public bus depot. That paints a picture of risk. Ask yourself this. If you were the judge, would you gamble community safety on promises after this sequence of events? Or would you shut the door and keep bond exactly where it is? Because in this courtroom, that decision just became inevitable.
That is
Is
correct.
that what I have here?
That is correct in terms of what happened procedurally. He is indicating that he has defenses to that domestic violence matter. And it's my understanding from him that he has not, in his 33 years, not had any domestic violence charges before.
Any response from the people? I don't really need it, but
I will do my job, even though I can absolutely pick up what the court is putting down.
oh,
Mr. Robinson was at Express Bus Depot, brandishing a firearm as a felon. It was about a 26-minute delay from the time that he was initially seen with the firearm until it was called into dispatch. Law enforcement arrives. He's still present at the bus depot with the firearm. Caused a lot of mayhem and fear. So I absolutely would be opposing any kind of reduction in his bond for that deason, in addition to the fact that he was picking up new charges while dealing with the current charges.
motion for bond reduction is denied. Bond will continue.
There it is. Clean, direct, no hesitation. Bond denied. This ruling sends a message, not just to Mr. Robinson, but to every defendant watching from the benches. When a judge says bond will continue, it means the court sees enough risk to justify keeping the defendant exactly where they are. And that risk isn't theoretical. It's based on timing, conduct, and credibility. Notice what didn't happen here. There was no long lecture, no dramatic explanation. Judges don't always explain denials in detail, especially when the record already speaks for itself. The combination of weapons charges, alleged domestic violence, and public safety concerns was more than enough. This ruling also shifts leverage. A defendant held pretrial has fewer options, more pressure, and a very different legal road ahead. It can influence plea negotiations, trial strategy, and even case outcomes. The courtroom may move on quickly, but for the person on the other side of that decision, everything just changed. Now, watch how efficiently the court transitions. One case ends, another begins. Different name, different facts, same system, and the next defendant is about to face a very different but equally serious problem.
Thank you.
And I apologize, I did not hear our next date.
Next date, I set it for February 12th. Thank you. Court calls case People versus Clarence Caldwell.
Victoria Bird here, assistant prosecutor, again, appearing on behalf of the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Caldwell, who appears via Zoom, Your Honor. Mr. Caldwell, will you please state your name for the record?
Clarence Caldwell.
Your Honor, I see that you likely have before you what I believe to be a bond violation. Is that correct?
Yes.
And I did have an opportunity to go over that with my client.
Where is he?
He is in the state of Kentucky, Your Honor. That's where he currently resides.
He's going to need to get here. But go ahead. This is what you want to do today.
Your Honor, I am just asking for an adjournment. My understanding is that we will likely have resolution in short order.
Then what I will do, I'll give him time to get up here because he's going to have to appear in person February 12th, 2026, 9 a.m. That's in person. We will deal with both his probable cause conference and bond violation.
Thank you, Your Honor.
This time his bond continues.
Thank you.
Court calls the case People versus Derek Riles.
Public Defender Hannah Apple appearing on behalf of
I can get
Mr.
out
Riles.
of here.
Mr. Riles, can you state your name for the record?
Derek Riles. Thank you.
You just got it. Mr. Riles is asking that this matter be set for preliminary exam.
Who is? Got him muted or kicked out. He wants an exam on this.
Yes, Judge.
Is discovery complete on it?
Your Honor, we are not in receipt of the video discovery. I did reach out to Ms. Tanhai yesterday, which would be the officer's body worn camera when they responded. She did let me know that she would look at the file. Have not received it from the officers. I explained that whole process, the position it would put his attorneys at if we did not have that video prior to the preliminary examination. At this time, he's asking that the matter still be set for preliminary examination, understanding those risks.
And that's what I think that, as of, I think, late last night, I believe we did receive the video.
Oh, okay.
But if they're not here, I'm not gonna an adjournment will not happen.
Yes,
You
he understands.
understand that, sir?
The first sentence, I didn't hear. What did he say?
If the video is not here on the exam date, you will not get an adjournment for that purpose. You understand that?
I want, yeah.
You understand you're not going to get an adjournment of your preliminary exam if we don't have the
want
video.
it.
This is a textbook example of judicial firmness. Derek Ryan wants a preliminary exam, even though critical video evidence may not be available yet. The judge doesn't stop him, but he warns him, loudly and clearly, no adjournments later. No excuses if the evidence isn't ready. That warning matters. A preliminary exam is not a formality. It's the prosecution's burden to show probable cause. Defense attorneys often rely on discovery, especially body camera footage, to challenge credibility or suppress evidence. Proceeding without it is a calculated risk, and Judge Simpson makes sure the defendant understands exactly what he's walking into. This moment shows respect for autonomy paired with accountability. The court allows the defendant to choose, but locks the consequences in place. That's how the system protects efficiency and fairness at the same time. Would you gamble a preliminary exam without seeing key video evidence? Or would you delay and risk sitting longer in legal limbo? This is one of those decisions that separates strategic patience from aggressive defense, and it can shape the entire case trajectory.
Okay.
Preliminary examination in person, February 3rd, that people can have their witnesses available that day. February 3rd, 2026, 9 a.m. before me. Bond will continue.
Thank you.
Court calls the case of the People versus James Wilson, 2 cases.
Veronica Glenn on behalf of Mr. Wilson.
Mr. Wilson, can you state your name?
James Wilson.
Thank you, sir.
Your Honor, we would like to set this case for a preliminary exam.
Both of them?
Yes,
Discovery is complete.
yes.
People have their witnesses available the 3rd.
Yeah.
Preliminary examination in person, February 3rd, 2026, 9 a.m. before Judge Perry. Bond will continue.
Thank you.
Court calls the case People versus Daniel Sims.
Victoria Burton here as Chief Assistant Prosecutor, again appearing on behalf of the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Sims.
Your name, sir?
Daniel Simpson.
Thank you. What are we doing?
Yeah, this is going to be a waiver. Mr. Sims has some matters up in Judge Conlon's court. We're asking to waive this exam so this matter can go up there as well for a global resolution. I have gone over, or Mr. Sims is aware of his right to an exam and wishes to waive.
Mr. Sims, you understand you're waiving your right to a preliminary examination in this matter?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive it.
Yes, we do, Your Honor.
Preliminary examination having been waived, defendants bound over to 3 counts.
Waiving a preliminary exam is never casual, even when it sounds procedural. Daniel Sims gives up a powerful opportunity, the chance to test the prosecution's case early. But this waiver isn't accidental, it's strategic. The defense mentions a global resolution, which usually means multiple cases, multiple courts, and a coordinated negotiation. By waiving the exam, the case moves faster to circuit court, where broader plea discussions often happen. The judge carefully ensures the defendant understands what he's giving up, the right to force the prosecution to prove probable cause right now. Once waived, that door closes. This is where legal chess comes into play. Speed versus leverage, efficiency versus exposure. Sometimes defendants waive hearings to consolidate cases, reduce penalties, or align sentencing across jurisdictions. Ask yourself, is faster always better in the justice system? Or does speed sometimes cost defendants their best leverage? These quiet decisions often matter more than dramatic courtroom arguments, and they happen in moments just like this.
Thank you, Your Honor. In terms of Raymond on the information, we'd waive reading, stand mute, acknowledge receipt.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
February 4th at 1:30 before Judge Conlon.
February 4th, 2026, 1:30 before Judge Conlon.
Thank you, Your Honor.
Bond continued. Court does call the case, People versus Vasquez Davis.
Morning, Your Honor. Raymond Cook for the people.
And Assistant Public Defender, tonight to carry out the plea, Your Honor, on behalf of Mr. Vasquez Davis, who's approaching. Vasquez, state your name for the record.
My name is Vasquez Davis, sir. How you doing today, sir?
I'm doing fantastic. Yourself?
Yes, sir.
You cold?
A little bit.
Yeah, okay. And you're doing okay. All right. You're requesting an adjournment?
We are, Your Honor.
Probable cause conference will be adjourned to February 12th, 2026, 9 a.m. Bond continued.
This brief interaction with Vasquez Davis feels lighter, but don't mistake politeness for lack of consequence. The judge engages casually, even asking if he's cold. That human moment contrasts sharply with the authority behind the ruling. The case is adjourned. Bond continues. Nothing changes, for now. Adjournments are often misunderstood. They aren't wins or losses. They're pauses. And pauses can favor either side depending on preparation. Bond continuing means the defendant retains freedom, but also remains under court control. Any misstep between now and the next date can shift everything instantly. What stands out here is courtroom rhythm. Some cases explode with conflict, others slide quietly forward, but every single one carries the same underlying truth. Compliance matters. Miss a date, violate a condition, pick up a new charge, and you'll be standing where others already fell today. Which approach do you think works better? Strict enforcement or measured? Patience? Because Judge Simpson demonstrates both, depending on the situation.
All right.
Thank you.
All right,
All right, bye. Take care. Bond continued. He's gone. Court calls the case, People versus Alicia Whittenberg.
Alex Jablowski for the people. Assistant Public Defender Jay Bellinger on behalf of Ms. Whittenberg. Your approach is, Your Honor.
Your name?
Alicia Whittenberg.
All right. Have before me a plea form that indicates that she's going to plead to count 2, operating while intoxicated, second offense. She's going to plead guilty to that charge, the 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. There is further an agreement that the defendant would be sentenced. The plea agreement is contingent upon entry into the 14B recovery court.
That's correct, Your Honor.
Has she been accepted?
She has been accepted, and the paperwork should be there and signed in front of you.
May I have her sworn?
Right ahead. Do you solemnly swear in front of the testimony you're about to give will be the truth, the whole truth, and nothing but the truth self you got?
I do.
State your name, please.
Alicia Renee Whittenberg.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of operating while intoxicated, second offense.
Correct.
That is a misdemeanor punishable by up to 1 year incarceration, a $200 to $1,000 fine plus court costs. The court could also order any community service or rehabilitative programs the court deems necessary, could order your vehicle immobilized, could order your vehicle forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
I do.
All right. You understand also, ma'am, that while I'm taking your plea, I would not be your initial sentencing judge, but you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Judge who?
Barr?
Okay. I thought it was Washington, but yes, that's fine.
Well, ultimately, that's where we'll end up.
Okay.
All right.
I'm sorry.
But you understand that?
Yes, thank you.
All right. Understanding all of that, do you still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
I do.
You signed an advice of rights form or had one signed on your behalf?
Yes.
Any question regarding those rights? You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that with pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
I am.
And also because you believe that you're guilty?
I do.
June 28, 2025, at the location of Willis near Bunton in Augusta Township, Washington County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
I did.
Do you recall what you had and how much?
I do.
What'd you have?
I had almost a fifth of Captain Morgan.
All right. Were you stopped by the police or was there an accident?
Accident.
What happened?
I went into a ditch swerving from a squirrel.
This is one of those moments where the courtroom briefly shifts from grave to uncomfortable humor and then snaps right back. The admission is clear, nearly a fifth of alcohol, a blood alcohol level of 0.28, and a second offense OWI. That number is not borderline. It's more than 3 times the legal limit. The squirrel comment draws a reaction, but the facts don't soften. The judge does something important here. He keeps control without cruelty, acknowledges the comment, redirects, and returns to the seriousness of impaired driving. The penalties outlined are extensive: jail time, fines, vehicle forfeiture, and mandatory treatment. This isn't symbolic accountability. It's real. Recovery court acceptance is the lifeline here. That program emphasizes treatment over punishment, but only if the defendant follows every rule. Any misconduct between plea and sentencing could undo everything. This raises a hard question. Should repeat OWI offenders be prioritized for treatment or punishment first? The court is walking that line carefully, and the next ruling will show just how tight that balance really is.
You what?
I swerved to miss a squirrel and went into a ditch.
Should have hit it.
I know. I teach
All
that in
right.
driving.
Anyway, I know, but that was wrong. Alan made me say that.
Oh,
He's
did he?
not a big squirrel fan. All right. That was very wrong. Did the police arrive?
They did.
All right. Were you taken to the hospital?
I was.
All right. And was there blood draw?
There was blood drawn, yes.
And what were the results of that blood draw?
I believe it was 0.31.
0.28. We would stipulate to the 0.28 lab findings, Your Honor.
It was 0.28.
That's correct.
Thank you.
Of course.
All right. And you have no reason to dispute those blood test results, correct? Had you previously been convicted of operating while impaired on or about August 15, 2025 in the 34th District Court and or operating while intoxicated on or about August 9, 2017 in the 34th District Court?
You said 2025 or it was 2005?
2005. Did I say 25?
Yeah.
2005.
Yes, sir.
All right. Ma'am, if I accept your plea, I do have to advise you between the time of my acceptance of your plea and your time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
I do.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No. None, Your Honor.
All right. And have I complied with the court?
Yes. Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter before Judge Barr will be
February 3rd at 10 a.m.
February 3rd, 2026, 10 a.m. before Judge Barr. Bond. Continue.
Your Honor,
You want me to, okay, go ahead.
I would ask to renew my bond argument. I understand that this court has heard this before. I understand also that the court is aware that Ms. Whittenberg has been able to be released as upon the court order to an inpatient facility. However, the insurance in this case is not allowing, due to the fact that she has insurance, she's not allowed to be, she can't be released into an inpatient facility successfully. We would ask that she be able to be released on her own personal recognizance. She again does do.
I'll let you go on, but I am disinclined to change your bond at this point. I would let Judge Barr, in consultation with what's happening at 14B, once that is occurring, view everything and make a determination as to whether that she would be released. Because they're going to have the most updated information.
If that is the court's order, Your Honor, then I will not continue.
That's my order.
Okay.
Bond will continue. Thank you.
Today's docket shows the justice system in its raw, unfiltered form. Multiple defendants, different charges, one consistent theme: accountability. Judge Simpson applied the law with precision, denying bond when risk outweighed reassurance, enforcing personal appearances, honoring strategic waivers, and approving recovery pathways when appropriate. Kent Robinson's bond denial underscores how quickly freedom disappears when conditions are violated. Clarence Caldwell's case highlights the limits of distance and delay. Derek Ryan's hearing reminds us that strategy carries consequences, and Alicia Whittenberg's plea shows the court's willingness to balance punishment with rehabilitation without ignoring the danger of repeat offenses. This isn't television drama. These are real people navigating real consequences in real time, and every ruling sends a signal about responsibility, risk, and the court's role in protecting the public. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.